Hi guys, this is part 2 of our sessions on fundamental rights. In the first session, we discussed the basics of fundamental rights and right to equality, which is enshrined under Article 14 to Article 18 of our Constitution. Let's look into session 2 and understand as to what the lengthiest written constitution of the world has to offer to us. Now, in this session, we will discuss another fundamental right, which is right to freedom. Right to freedom is enshrined in Article 19 to Article 22 of the Constitution, and it provides us various freedoms on which our day-to-day life is based. We also need to understand that Article 14, Article 19 and Article 21 are the most widely interpreted articles of the Constitution, and they're together called the golden triangle of the Indian Constitution because these are the basic rights on which enjoyment of life of a citizen is based. Now let's come to Article 19 of the Constitution. So Article 19 is divided into two parts. First one is Article 19 Clause 1. The other part is Article 19 Clause 2 to Article 19 Clause 6. Article 19 Clause 1 provides us various freedoms. So there are 6 freedoms as you can see that are enlisted under Article 19 Clause 1. These are right to freedom of speech and expression, right to assemble peacefully without arms, to form associations and unions, to move freely throughout the territory of India, to reside and settle in any part of the country, to practice any profession, trade, business or occupation. Now these are the 6 freedoms that Article 19 Clause 1 provides us. Article 19 Clause 2 to Article 19 Clause 6 provide us various reasonable restrictions that the government can place on the enjoyment of these fundamental rights. So Article 19 is not absolute in nature. There are certain reasonable restrictions that can be imposed. Now as you can look at this table, you will realize that there are specific reasonable restrictions that can be imposed on specific freedoms that are given. For example, you can see that there are 6 reasonable restrictions for right to freedom of speech and expression. However, totally there are 8 restrictions in all. Now if there is a question which says that the act of the government was such that it violated the fundamental right of freedom of speech and expression. However, the government argues that it violated this right because it is not absolute and it violated in the interest of general public. Now if you have a look at the chart again, interest of general public is not a reasonable restriction which is enlisted under right to freedom of speech and expression. Therefore, the argument of the government with respect to general interest will not prevail in a court of law. So what I'm trying to say here is that only specific reasonable restrictions pertaining to particular freedoms hold good in law and no other reasonable restriction can be imposed as given in the Constitution of India. Now, Article 20 of the Constitution states that no person within the territory of India can be convicted of an offence which is not a law at the time of commission of an offence. Now what does it mean? It means that if I commit an act today and tomorrow there is a law for this that this particular act is an offence, I cannot be convicted for that act because at the time of commission of that act it was not an offence. Similarly, no greater punishment can be given to that person as is mentioned in the law. So for example, I commit an act today and for this particular act the punishment mentioned is 2 years of imprisonment. Now I cannot be given a punishment which is more than 2 years by any court in India for that offence. This is a fundamental right which is guaranteed by the Constitution of India. Article 20 Clause 2 states that no person can be convicted for the same offence twice. This doctrine is called the doctrine of double jeopardy. This means that once a trial has taken place against a person and a person has been convicted for an offence, he cannot be convicted for the same offence by conducting the trial again for that offence. This is mentioned in Article 22 of the Constitution is called the doctrine of double jeopardy. Article 20 Clause 3 talks about right against self-incrimination. It means that if any investigative authority or any police authority catches any person and that person is taken into custody, the police or any investigative authority does not have the right to compel the person to testify against himself. So basically किसी के साथ जबरदस्ती नहीं की जा सकती कि आप खुद के खिलाफ बयान दो या फिर खुद के खिलाफ एविडेंस दो. That is not on the person who has been caught. Also to be noted that this person who has been caught, the testimony given in front of the police authorities is not admissible as evidence in court. Only the testimony which is given in front of a magistrate or in a court is admissible in the court of law. Now we move on to one of the most widely interpreted articles of the Constitution, which is Article 21. It is popularly called the right to life. It says that no person shall be denied the right to his life and personal liberty except according to the procedure established by law. Procedure established by law means there could be certain laws which provide certain reasonable restrictions on the right to life. Now, right to life has a very wide meaning. In the case of Khadak Singh, it was held that right to life does not mean mere animalistic existence. It means a lot more than that. It means all the basic necessities of life that a person should get. So, right to life includes a lot of rights. So, as you can see, it includes a lot of rights, which is right to health and medical care, right to privacy, and so on. There is a list of rights that have been interpreted at various times by various high courts and the Supreme Court of the country. Now, another question that comes to our mind is, does right to life also includes right not to live? Can we take our own life? Now, that is not allowed in the Indian Constitution. There are certain safeguards for that. So there was this landmark case of Aruna Shanbhag versus Union of India in this matter. Aruna Shanbhag was a nurse in the KEM hospital in Mumbai. In 1973, she was raped and sodomized by a fellow staff, and she was chained around her neck. Due to this chaining, her oxygen supply to the body stopped and she suffered from paralysis. Because of this paralysis, she could not move and she was in a vegetative state from that period, from 1973 to 2015 till the time she died. For a period of 42 years, she was brain dead and she could not do anything. It was her fellow nurses who took care of her. So in 2009, an advocate filed a suit in the Bombay High Court asking for euthanasia for Aruna Shanbhag. Now, what is euthanasia? Euthanasia, in simple terms, means mercy killing. Basically, killing a person who has been not responding or who is basically brain dead, in order to do away with the sufferings that that person is going through for a long period of time. Euthanasia is given to people and it's allowed in certain countries. However, there are two types of euthanasia. First one is active euthanasia. Second one is passive euthanasia. Active euthanasia means giving certain lethal injections from the outside to a person so as to kill that person. The second type of euthanasia is passive euthanasia, which means to take out the life support of that person. So, for example, taking out the oxygen mask, not giving food to that person so that that person dies eventually. That is passive euthanasia. After the Aruna Shanbhag judgment, it was allowed in India. Passive euthanasia was allowed in India. Now, there are certain procedures required to prevent its misuse. So, there is an application to be filed to the High Court. The High Court then constitutes a committee of doctors who look into this matter, and there are certain other procedures. As you can see, in 2018, the Constitutional Bench of the Supreme Court in Commerce Cause versus Union of India allowed living wills and finally reaffirmed the Aruna Shanbhag judgment wherein passive euthanasia was legalized. Now, in 2002, by the 86th Amendment to the Constitution of India, there was another article inserted called Article 21A, which brought forth another fundamental right called right to education. Right to education was inserted in 2002 by the 86th Amendment. It says that it is the duty of the state, basically the government, it is the duty of the government to provide free and compulsory education to every child in India. Basically, it is the duty of the government to provide elementary education to every child in India. There was this act to prescribe procedure for this entire fundamental right, and this act was called the Right to Education Act 2009. And recently there was a change in this act with respect to the no detention policy. So there was an amendment made in 2019 wherein earlier in the 2009 act, no student from the age 6 to 14 was allowed to be detained. Now this policy has been done away with, and it is upon the state government to finally decide whether this can be done, whether that person can be detained or not. Now the last provision for today that we discuss is Article 22. Article 22 provides us certain protection in case of our arrest or detention. So Article 22 states that whenever any police authority or any other investigative authority arrests us, we are bound to know the cause of arrest. We should know as to what is the reason for which we are arrested. We are also bound to have a company of our lawyer. We are bound to ask for a lawyer for legal advice. This is a fundamental right that is enshrined in Article 22 of the Constitution. Also, no authority can keep us in police custody for more than 24 hours without producing us to the magistrate. So 24 hours is the maximum cap for which we can be kept in the police custody without producing us in front of the nearest magistrate. Now there is an exception to it. So the exception is preventive detention. Now what is preventive detention? It is detention of a person on the suspicion that such person might be dangerous for the security of the state, or with respect to foreign affairs could be an alien enemy. So these are certain people who can be kept in custody for more than 24 hours up to a period of 3 months. However, there can be certain situations where more custody of that person may be required. For this, there is a committee constituted called the advisory board, and advisory board has all the people who are eligible to be the judges of the high court or who are the ex-judges of the high court. They are made to sit and then they finally decide if more than 3 months can be allowed. So there is an act in India called the Preventive Detention Act 1950 which allows for preventive detention of up to 12 months. Also, the parliament can pass certain laws which can prescribe the procedure for this advisory board to function. The parliament can also pass laws which can basically put certain kind of offenses and certain kind of people within the category of preventive detention without even requiring the advice of the advisory board. Now that is about our session 2 on fundamental rights. If there are any doubts, you can always write to us on our mail ID which is mentioned in the description. You can always have a look at the important links on this issue which is also mentioned in the description. If you like our videos, please subscribe to our channel and press the bell icon so that you don't miss any updates from us. Thank you.